Okay, I think we're ready to go, David. Good morning, everybody. Welcome to today's webinar, Martyn's Law, an overview of the Terrorism Protection of Premises Act 2025. I'm delighted to welcome not only our existing clients, but some new faces to our webinar this morning. A little bit about Ark, for those of you who do not know who we are. We have been in the built environment industry for just over 30 years. We classify ourselves as one of the industry leaders when it comes to delivering tailored solutions, end-to-end solutions for our clients with regards to people, property and operations. Our values internally based on trusted risk and compliance partners with our clients, and we're hoping that you will enjoy today's webinar. So a little bit about the agenda today. So we're going to give you a background of Martyn's Law and an overview of that. Some of you will be aware that obviously on the 22nd of May 2017, there was an attack within the Manchester arena. Following on from that, the Manchester inquiry released in November looked at recommendations to not only strengthen security, but emergency responses and regulations. So David is going to take you through that legislation in a little bit of detail today. We're going to be taking a look at the persons responsible for that, so owners, potentially property managers. We're going to be taking a look at qualifying premises, and from talking with David earlier, I believe there's certain premises that will fall into scope that might surprise you when it comes to this particular act. We're going to be talking about the type of events that fall under the scope, and most importantly, some events that do not. And then we're going to take through the duties and the regulatory and the offences associated with this Act too. So we've got a number of polls today. We're also going to ask for feedback as part of our webinar at the end. So if you could take part, that would be really great. We will hopefully have time for question and answers at the end as well. So the first poll of today is: do you own or manage a building where members of the public are invited, or where a large number of persons may even occasionally attend, whether for payment or not? Yes or no, please, if you wouldn't mind submitting your answers now. Just getting our responses, David. Interestingly, yes, seems to be coming up. These buildings. Okay. Brilliant. So I think we've got 54% at the moment, 46% now. So I think we can get started. So no introduction required for our speaker today. David Hills has been with Ark now for over 25 years and is our Senior Director for Technical and Technology Solutions. David also holds, interestingly, a certificate for Public Safety and Event Administration. So he is absolutely guaranteed to bring you through Martyn's Law in a lot of detail today. So David, without further ado, over to you. Thank you.
Thank you, Shaunna. Hope everyone's well. I'm just going to start straight away by just talking about the current security threats. The UK's current threat level is identified as being substantial, which means effectively that the possibility of an attack is likely. Now, there are 5 levels of threat: low, moderate, substantial, critical, severe, and then critical. And the level is actually set by the Joint Terrorism Analysis Centre and the Security Services, MI5. So why is this important before we go through this particular process? Threat levels do not have an expiry date. Threat levels are not set in stone. They change over time as different information becomes available. So what we know at the moment is that an attack is likely. It means that all of us need to be vigilant. All of us need to ensure that if we own, manage, or lease a building where members of the public are in occupation, or could be, or even if you have an event running, that you need to ensure that you understand the risks posed and what plans you have in place in order to keep people as safe as possible. Now, we would strongly recommend that you, on a regular basis, check out the security threat. We actually undertake it every week just to make sure that we understand exactly what's happening. And I've provided you there with a link, direct link to the actual website where you can actually go through that current security threat. So Let's talk about the background. As Shaunna was mentioning there, on the 22nd of May back in 2017 at the Manchester Arena, an Ariana Grande concert was being held, and it was attended by 14,400 people, mostly young people. Now, at the end of that concert, around about 10:35 p.m., a lone suicide bomber detonated a homemade improvised explosive device known as a PBIED, person-born improvised explosive device, in what's called the City Room. Now, the City Room is an area close to one of the major exits from the arena, and it leads to the Victoria Railway Station and also the car park. The result of that bombing was that 22 people were killed and over 1,000 people were injured. And as Shaunna was just mentioning there, the government then set up a public inquiry. That public inquiry was a statutory public inquiry chaired by the Honourable Sir John Saunders. And he looked at three specific areas. He looked at the arena's response, he looked at the emergency services response, and he then looked at the security services separately. And when it came to the arena's management team, he basically suggested that management had an inadequate risk assessment that was insufficient. It failed to provide sufficient rigor to the risks associated with the terrorist threat. And whilst the security arrangements and the team at the arena should have prevented or minimized the attack, the arena's management, he suggested, missed very, very clear opportunities to prevent that attack. There are videos and you'll see photographs in the report that actually takes you through the fact that the bomber was actually on site for a significant period of time, and he was never ever questioned. And in fact, many of the measures that were put in place that's within the risk assessment were just ignored, and they failed to identify that the use of patrols as a mitigation measure against both hostile reconnaissance and person-borne improvised explosive devices in the City Room were just completely missing. Mr. Honourable Saunders mentioned as well that the emergency and security devices response was wholly inadequate. There were significant missed opportunities that were noted that could have prevented the attack. There had significant files on the actual bomber. The emergency services decided not to send in teams to support those injured for over an hour due to the unknown risk of secondary devices, despite the fact that there were a couple of ambulance staff who were already in the actual City Room area, trying to support and requesting additional help. Nobody actually attended for over an hour. So he suggested that the emergency response and the management from all parties was uncoordinated, it was poorly managed, and it was completely inadequate, suggesting ultimately there was a significant failure in multi-agency response that actually undermined the ability to respond and save lives. And in fact, one of the elements, one of his findings was that effectively that lack of coordinated and managed response actually did lead to some of the deaths of the young people involved. His final report, which came out in 2022, suggested a number of things, such as improving venue security and greater vigilance in identifying threats. It was all about ensuring that there was faster medical intervention, better coordination between emergency services, and importantly here for us anyway, better training for staff. And then in addition to that, there was a need to establish a regulator to actually have mandatory risk assessments and to improve oversight of counter-terrorism strategies. Now, one of those killed was a young gentleman called Martyn. He was aged 29, and his mother, Finan Murray, has since that bombing been tirelessly campaigning and has received an OBE from the government for she's been trying to make sure that there's been legal reform and ensure that all public venues have appropriate security and response measures in place. Now, on the 3rd of April this year, Martyn's Law, which is now known as the Terrorism Protection of Premises Act 2025, received royal assent. And that new act doesn't just apply to England or to Scotland separately. It applies across the whole of the UK, England, Scotland, Northern Ireland and Wales. Now, the requirements of the Act are, according to the government, going to be implemented over the next 24 months, because the Act itself is an enabling Act. It requires statutory instruments to be passed through Parliament in order to activate the various requirements, the various clauses, and the various regulations and requirements. So let's go through the Terrorism Protection of Premises Act. I'm going to use the word Martyn's Law going forward. It's a very tight act. It contains 38 regulations and 4 schedules, and effectively provides 4 layers of requirements. Firstly, it sets out the responsible persons, which effectively are persons who are in control of premises, and then the Act makes them responsible for public protection in the areas that they are responsible for. It also creates a new regulator, and that regulator is going to be the Security Industry Authority. That is currently in place, and they are gearing up now in order to ensure that they can deliver what they're required to do under the Act. The Act then defines the buildings, the spaces, and the events that are actually going to be covered, separating them into standard premises, enhanced premises, and then qualifying events. And I'm going to spend a little bit of time later on just quickly going through those particular events and the uses of those particular premises. The Act then sets out duties for those responsible persons, which includes things such as assessing, risk assessments and evaluation, the development of what's called public protection procedures, both in respect of standard and enhanced buildings, notifying the SIA, making sure that people are actually undertaking training and exercises, cooperation and coordination, and in addition to that, where we are talking about responsible persons, the term person can also mean a legal entity, and so therefore certain legal entities, especially for enhanced premises and for events, have to nominate certain persons. And then finally, the Act, Martyn's Law, effectively provides methods by which the law is going to be enforced and implemented. It provides and allows for the SIA to issue notices if they are unhappy with certain work. It sets out particular types of events, especially offences for senior managers, so where there is consent, connivance or neglect. But in addition, the SIA are going to be allowed to issue what's called penalty notices, and they are notices where they are allowed to, without going through the courts, allowed to set penalties, and some of those penalties are extremely high. So I will take you through those particular parts there. So let's have a quick look at what the actual purpose is. The purpose was to, and is to, enhance protective security and preparedness across the whole of the UK by ensuring that those who are responsible for certain premises, certain parts of the premises, and certain events consider how they would prepare and respond to a terrorist act. Now, the Act then requires persons who are in control of certain premises and events to take steps to reduce the vulnerability of their premises or that event, and then assess the risk of physical harm to individuals arising from acts of terrorism. And the scope applies to a very wide range of buildings, public spaces, venues, events, and locations where the public or large numbers of persons actually gather. So what I want to do now is to spend some time looking at who are the responsible persons and look very specifically at what is a qualifying premises or event. So, persons who hold responsibility are effectively split into two particular parts. The first part is all about what's called a qualifying premises, and a person is responsible for a qualifying premises if that person, and that person, as I said, can mean a corporate body or entity, if that person has control of the premises in connection with their relevant use. And then a person who is a qualifying person in respect of an event is someone who is responsible for that event, and they have control of the premises at which the event is to be held in connection with their use for that event. So effectively, if you have control in part or in total for either a qualifying premises or for a qualifying event, or the land or the property in which that qualifying event is within, then you are going to be a responsible person. Now, if there is more than one responsible person for a particular premises or an event, then the Act basically says that both parties have to act jointly in complying with the requirements, and therefore there is a need to cooperate and coordinate. But the Act makes it very clear both parties must act jointly in complying with the imposed duties upon them. So you're not, just because, and really, if you think about it, take a large shopping centre. You could have an anchor store within a large shopping mall. The shopping mall owners are clearly going to be a responsible person, but also the person who is in control of the anchor store is going to have that responsibility as well. So both parties, therefore, have to act jointly in looking to comply with the Act. So who are we talking about? We're effectively talking about owners and operators of qualifying premises and their property managers, depending upon what level of responsibility those property managers actually have. And then, of course, we're also talking about tenants and operators of qualifying premises. As I said, a person who leases a building or part of that building, such as a large shop within a shopping centre, will also be the responsible person. So effectively, if you are responsible for a qualifying premises or part of that premises or event, or a part of the premises or the premises itself for a qualifying event, you hold responsibility. So it's quite a wide range in respect of catching a lot of people under this particular Act. So they're the people who hold responsibility. We'll keep on talking about qualifying premises. So let's switch our attention to have a look at that. So a qualifying premises is a premises that consists of a building or a building and other land. And for the purposes of what we talk about building here, that then the definition makes it very clear that it can include part of a building or a group of buildings, and that the premises are wholly or mainly used for one or more of the specified uses that are outlined within Schedule 1 of the Act. And I'm going to go through those specified uses in my next slide. But let's start looking then at what we mean by qualifying premises. And now there are, again, two types of qualifying premises. The first type is what's called a standard duty premises. And a standard duty of premises is one where it is reasonable to expect that from time to time, so it doesn't have to be permanent, it can be a one-off situation where you have 200 or more individuals who may be present on the premises at the same time, even if, as I said, that is occasionally. And I've just got a picture here of around about what 200 people actually looks like. So a qualifying premises that holds more than 200 persons is going to be covered by this Act, and therefore there will be duties that the responsible person will have to hold. But the Act then takes us into another stage as well, and we have what's called an enhanced duty premises. So if it is reasonable to expect that, again, from time to time, that you will have 800 or more individuals present on the premises at any time, again, even occasionally, then again, you will be, in this instance, an enhanced duty premises. You will still be a responsible person, but you will have enhanced duties in which to deal with. And again, another picture here, that's around about 800 persons in or what it actually looks like. So qualifying premises then are really important. So it all comes therefore now down, if we're not just now talking about the size of property, so 200 or more, possibly within your building, then you have a responsibility. But what type of buildings are we talking about? What uses of buildings are we talking about? Now, within Schedule 1, it's a significant list and it goes into a great deal of detail, but I've just picked out a few of the typical ones that we could be talking about here. So we are talking about shops and shopping centres. So if anything's used for retail, sale of goods, display of goods, or the provision of services, etc., where there is a sale and display of service that is principally for visiting members of the public, then that is considered to be a qualifying premises use. Any food and drink outlets, so restaurants, cafes, bars, anyone selling food or drink, again, for the consumption on the premises by visiting members of the public, where you have more than 200 persons or could have 200 persons, then that again will be a qualifying premises under this particular Act. We're also talking about entertainment and leisure venues, so theatres, etc., ice rinks, any type of sports centres, those type of things, anything used for entertainment, leisure or recreation activities of any description, then if that is used for the benefit of visiting members of the public, then again, that could and will be considered to be a qualifying premises. And then, of course, we've got halls. Now, this is the interesting part. This is where we've got to start thinking a little bit outside of the box and where other buildings may be caught up within this. So halls were, venues for hire, for example, for events and activities, including lounges, halls, exhibition halls, or a conference centre, especially where those events or activities are for the benefit of visiting members of the public or visiting persons. That could include, for example, residential lounges, if those lounges are significantly large enough and you hold events in them. It could also include multi-use games areas. Again, if they are large enough to hold 200 persons or more and that they are hired out, then again, those particular types of property could become qualifying premises under the Act. So just very, very quickly, I'm just going to take you through the complete list. I've just mentioned, obviously, sports centres, entertainment and food and drink. But we've also got sports grounds, libraries, museums and galleries. I've mentioned halls already, but things such as visitor attractions, hotels, places of worship, healthcare, transportation hubs, childcare premises, and then secondary schools, further education establishments and higher education establishments as well. So we're talking about a significant group here, and there are some very specific requirements, especially when there are differences between the definition in both Scotland, England, Wales and Northern Ireland. So we really do need to get to grips with what is our building or part of the building that we are responsible for, and what responsibilities do we hold. Now, the government have included some excluded premises, and as I said earlier, premises can include land as well, but the excluded premises are, would you be quite surprised, if they are occupied by the Houses of Parliament, the Scottish Parliament, the Welsh Synod, and the Northern Irish Assembly, they are excluded. And then other exclusions are premises that meet the following criteria: any parks and gardens or recreation grounds or non-designated sports grounds or open-air leisure premises other than designated sports grounds where no measures are in place to check either the numbers of persons within that area, that you're not asking for payment, that you are not inviting people in, or that you require a membership to gain access to that particular premises. And again, remember, premises can include land. So there are certain exclusions that need to be taken into account. So if, for example, you're responsible for a park or a garden, then as long as you're not asking to for payment into that particular area, that you don't allow for invitations or memberships, and that you're not there to check numbers, then that park or garden or recreation ground, etc., would not be covered by the Act. Now, if you decide to put an event on in there and check the numbers and check and look for payment and invite people, or there's a requirement for membership, then that will switch to a particular qualifying event. So with that in mind, what I thought we'd do is run another poll if we could. So Hannah, if we could run that poll, I just really want to find out, do you own, manage, or have some level of control over what is called a qualifying premises, used for one of the specified purposes for which we just spoken about? Okay, well, we've had 140 responses so far, so that's really, really helpful. Thank you very much. 29% say yes, they do hold a standard duty premises. 10% suggest that they hold an enhanced duty premises. 13% don't know what level, but they do believe that they hold some level of duty. And about 48% say that they do not. Okay. So thank you very much for that. That's very helpful for us. So let's now start turning our attention from responsible persons and qualifying premises and use to what we call qualifying events. Now, events are actually dealt with differently within the Act. And a qualifying event is an event if, as I said, the premises at which the event is to be held actually consists of a building, land, or building and land. And in addition to that, and again, the building includes both part of or a group of buildings there, that members of the public will have access to that premises, that land or those buildings, for attending that particular event, whether it's by payment, invitation, or are members of a club or an association. And it is reasonable to expect that at some point during the event, 800 people or more individuals may be present on the premises at the same time in connection with the use of that event. So a qualifying event effectively needs to look at whether there is going to be 800 persons there. It doesn't matter whether they are paying, but it's got to be, that event has got to be on land or within buildings or both, and that they are going to be there at any one time. Now, again, there are some excluded events within premises or on land for use for worship, for childcare, or for primary, secondary, and further education. So those events that are held in those particular parts are unlikely to be included. or an event that is being undertaken within an excluded premises. So an event held within a park that is less than 800 persons will not therefore be required if as long as we are not asking for payment or invitation, or that you have to become a member of a club or association to attend. So it's quite a complicated set of requirements, and our strong advice would be you need to actually take legal advice to make sure that you know what level of duty you've got, whether you are a standard duty premises holder or an enhanced duty premises holder, or whether you are a qualifying event duty premises holder. Okay, so I mentioned all of those duties, so let's delve a little bit deeper into the duties just to make sure we understand fully what we're talking about here. So we've got a standard duty holder, and they will have a series of duties in which they've got to undertake. They've got to look at what's called a risk evaluation, to undertake effectively a statutory risk assessment, and some guidance has been issued by the Home Office in relation to this, which I will go through in a few moments. They've got to develop what's called public protection procedures. Those procedures have got to cover how you evacuate people from the building, how you evacuate people and lock down your building if the need is required, and how you communicate both with people who are in the building, but also how you communicate with the emergency services as well as the neighboring environment. So your next door neighbors who are or may be affected by whatever situation you are dealing with. It requires appropriate training and exercises, so preparedness exercises and training needs to be considered. It also requires you to notify the Security Industry Authority of your responsibility, whether it's standard or enhanced. And in addition, where there's more than one person, and that again, more than one company or organization, for example, that you cooperate and coordinate your activities so you act jointly. Now, enhanced duty holders have exactly the same types of duties, but they also have 3 additional areas that they've got to deal with. If you are an enhanced duty holder and you are an organization, for example, and not an individual, then you must nominate or a designated senior individual from within the management team. And again, that only applies where that enhanced duty holder is an organization, a corporate entity. In addition to the standard public protection procedures, you have to develop enhanced public protection procedures, which looks at how you monitor both the building and the people who are within the building, how you control those persons' movements, and then looks very specifically at the physical security arrangements that are in place and the security of information as well. And then in addition to that, you have to provide what's called an overview statement that has to be submitted to the SIA as part of your notification to them. Now, those duties then, I just want to very quickly break them down. So let's start off with risk evaluation. The government back in 2023 actually produced some draft standard terrorism evaluation guidance on how you should go through this particular process. Now, this was draft guidance back in 2023. We're in 2025, almost 2 years later. So this may change, but this is still on the Home Office's website. This is still available free of charge on that website, so you're able to actually obtain it. And it effectively takes you through a 3-phased approach. You've got to think about the types of events that you are holding and how you could become a target of a terrorist attack and the types of terrorist attack that are relevant to your premises. I think it's very difficult to actually do that unless you've got some sort of level of training of the types of terrorist attack, but those terrorist attacks as well are going to change over time. Terrorists don't stick by the same way of doing things. They look at alternate ways of delivering the terror in which they are looking to actually provide. And so we need to ensure that we are constantly reviewing this particular evaluation process. You need to therefore then put in plans based on each type of potential attack and develop an understanding of the key 6 areas: how you're going to warn people, how you are going to lock down your premises or evacuate your premises, how you would call the emergency services and how you would relay that information to them, and how you would therefore also supply first aid equipment and first aid provisions. And finally, consider how you could make your neighbours and the local area aware of that particular attack. And this is for each type of attack. So it's just not just going to have one particular approach. And then final part of this phase is to activate those plans. It's to keep those plans up to date. It's to review those plans on a regular basis. It's to develop and provide appropriate first aid and first aiders and first aid equipment applicable to your particular building. It's making sure that you develop a program to both communicate and train your staff and any of your contractors that you're using. And then also develop a program to exercise those particular plans. It's a waste of time having a plan if you don't know or have never used it. So you really do need to start thinking about how you can go through emergency preparedness and testing of your plans. So that's the risk evaluation at the moment. Now we are still awaiting guidance, and we are also going to see statutory instruments, so regulation that's going to therefore tell us exactly what we're going to need to do. But that's not going to come in this particular period. We've got a 24-month period from April in which we are going to see all of this guidance and all of the regulation be provided. So the public protection procedures effectively are formal written procedures that are to be followed by your staff and other individuals who are working within the premises or at an event where there is a reason to suspect that an act of terrorism is either occurring or is about to occur, both in your premises or even in the immediate vicinity of your premises. Now, what these public protection procedures have got to cover is effectively how you would evacuate individuals from your premises, or how you would move individuals to a place within your premises where there is less risk of harm. Those procedures have also got to cover how you can prevent individuals either entering or leaving the premises or event. And then finally, how you are going to provide information to individuals on the premises or at the event. Now, when you look at the way that the government have worded certain elements and certain parts of the guidance that have been issued so far, there is a clear resemblance between the requirements of the Terrorism Act and other safety-related legislation. Which, safety-related legislation often talks about risk profiling and then organising and making sure that you've got the right arrangements and policies and procedures in place. So we would strongly recommend that it's not a requirement in the Act, but if you're going to make this part of the day-to-day process, we would strongly recommend that you consider developing a formal management system in order to support you through this whole process. That management system is an iterative process. It will allow you to test, to check, excuse me, to make sure that you learn lessons and actually ensure that you have the right arrangements in place. Okay, let's move on from the protection then, and then start looking at quickly at training and exercises. Really important part of the whole process. One of the things that we found in the past that a lot of people have developed a lot of very, very good emergency procedures and arrangements, but they've never tested them. They don't know if they actually work. They don't know how their staff will respond. So really having good training and exercises with staff and with your security personnel will let you know how effective your procedures actually are and how effective your staff are at reducing harm and saving lives. It's going to really be important to check and assess those requirements because the regulator is going to be asking questions. The regulator will also be providing guidance as well on what type of exercises you should be looking at. But you need to make sure you're the responsible person. You need to make sure that you've got the right mitigation levels and the right measures in place to reduce your vulnerability to terrorist acts and obviously mitigate any risks. I think it's also important that we found in the past, and we still do a large number of what we call emergency preparedness exercises, which are effectively desktop exercises, but they are really good at giving staff that confidence that they know exactly what they need to do. But it also helps staff identify where there are safe routes and where there are not, where we've got lapses in security arrangements, and actually how their systems work. And again, it does allow them to gain a lot of confidence. And as I said earlier, the UK terrorism threat level is currently at substantial, meaning that an attack is likely. So preparedness training will really help and ensure that your staff and as well as that the management team remain vigilant and are ready to respond to what has to be an unpredictable threat. So let's move on from training down to notification. A person who is or becomes responsible or ceases to become responsible for a qualifying premises or qualifying event has to notify the security industry within a required period of time. Now, as I said, that required period of time is going to be set in law. The Home Secretary, to whom the Security Industry Authority reports, is going to set out all of the additional regulation that will tell you exactly how and which form you're going to have to provide the information, as well as the manner in which you'll have to provide that information as well. So that notification process is going to have to be taken place. And again, at the moment, we still don't know exactly how much time you're going to be given, but certainly there will be guidance coming out. And at some stage over the next 2 years, those who are responsible persons for qualifying premises will have to notify the SIA. Just coming towards really the end of what I really wanted to cover, and then just want to talk about cooperation and coordination. So if one or more person is responsible for a qualifying premises or a qualifying event, then both of those parties have to cooperate where reasonably practicable with each other to comply with the requirements imposed on them. Now, if a person is not responsible for an enhanced premises, but has control to any other extent of the premises or part of that premises, then that person also has to be involved and has to cooperate with the person who is the responsible person for that premises or event. So you might have you might not be a qualifying premises, so you might be a very small shop in a shopping mall, but you will have to also ensure that you cooperate with the person who is responsible for the shopping mall, especially where there are certain requirements imposed on them. Just really want to then focus very quickly on enhanced duty requirements. Those who are responsible for enhanced duty requirements, as I said earlier, are required to develop these procedures and systems over and above those for standard duty. And the idea is to reduce the vulnerability of the premises to events of acts of terrorism, to reduce the level of physical harm if an event actually happens, or if an act of terrorism actually were to occur, both in the premises or within the immediate vicinity of the premises. And these new procedures have got to include, as I mentioned earlier, monitoring of the premises and the immediate vicinity, monitoring and movement of individuals, both in, out, and within the premises, physical security of the premises, and the security of information. And that person must ensure that all of this is dealt with within an overview document, which basically states the procedures that you have in place, how those procedures will effectively reduce the risk, and a statement of all the measures that you're putting in place. And the government have put in a very interesting statement to turn around and say, and any further information as the Secretary of State may by regulation specify. And now, interestingly, under the law, the person who, in this instance, an enhanced duty person, must ensure that a copy of that document, that overview document, is provided to the SIA as soon as reasonably practicable after it has been prepared, but if it is revised within 30 days of its revision. And finally, in respect of enhanced duty requirements, you've got to specify a senior individual. So where the responsible person is not an individual, then that responsible person must designate an individual who is concerned in the management or control of the registered premises as having responsibility for ensuring that the registered premises complies with the requirements. So that's a direct quote from the actual Act itself. So just really want to finish off then and just very quickly look at the regulator and the offences that can be assigned, and what type of fines are we actually talking to. So the offences are very clearly defined within the Act and allows for the SIA to actually undertake proceedings where in England and Wales on summary conviction, you could be liable to imprisonment for a term not exceeding the general limit, which is about 6 months in England and Wales through the Magistrates Court, and or a fine of £5,000. If it's in Scotland, that imprisonment term extends up to 12 months and the fine moves up to £10,000. And if it's in Northern Ireland, then it moves back again to how it is within England and Wales. But they are the lower court elements. That's the summary convictions. If, for example, the court pushes it up to a higher level court, a Crown Court, for example, or a similar one in Scotland, then on indictment, then the term of imprisonment can go up to 2 years or a fine or both, and that fine at the moment is currently unlimited. So very interestingly, we've got different elements on how this would be regulated in different parts of the UK. The requirements are there, requirements are the same, it's just the results of what could happen if things go wrong will be different. I think finally, the last part I want to cover here is the offences and penalties that can be served directly by the SIA. So they can actually serve notices, both compliance and restriction notices, and they can also impose what's called penalty notices on responsible persons. So if, for example, you have a penalty notice served against you, so for you failed to attend a meeting with the SIA or failed to provide information, then they can impose a penalty on you directly without having to go to court of £5,000, which will have to be paid within 28 days. And if you fail to meet the requirements of the Act, the maximum penalty can be £10,000, or if you are an enhanced duty premises or event, the maximum fine can be £18 million. I haven't put too many zeros on there. £18 million, or 5% of the qualifying worldwide revenue, whichever is the greater. Now, there are certain requirements and certain guidance that the SIA will have to follow. For any enhanced duty premises holder or event, they will have to liaise with the Secretary of State in respect of imposing any of these penalties. But they, as I said, they can actually impose those penalties, but they can also impose daily penalties as well. So each day after the end of the period specified for payment for any non-compliance penalty notice, then again, if it's for a standard duty premises, that figure could be £500 per day. And if it's for an enhanced duty premises, it could be £50,000. That's £50,000 per day. There are, though, arrangements to allow for people to appeal against those imposed penalties. But I can see very clearly, and it's very typical of how regulators, when they first start these processes off, where they're given these powers, they are going to want to make a statement. That's not their intent, but that's effectively what actually happens. And it's only going to be at that stage that people are really going to take notice of the whole process. Okay, last couple of slides. If an offence is committed with the consent, connivance of a relevant person, so where we have a corporate entity and a relevant person, if, for example, is an officer of that particular body, or any other person who's concerned with the management or control of that particular body, if they can consent or connive, or they are neglectful in their duties, then both the person as well as the body commits the offence and is liable to be proceeded against and punished accordingly. Now, this approach is used in many different pieces of legislation. The Building Safety Act has it, the Security Act has it, and we've already got, in respect of the Security Act, a case that was back in 2011, the Regina versus Anthony Hutchins and Regina versus Georges Chambrois. It's worthwhile having a look at that, because effectively you cannot just accept the fact that I didn't know. That is neglect. I didn't ask. Well, that is connivance or consent. You need to make sure that you ask the right questions, the right people at the right time, and do something with the answers. They were the last of my slides. I just really want to take you through some very, very quick takeaways. The Act is in place. It's passed. We are awaiting secondary legislation. We now need to start preparing for its implementation. The concept of responsible person, qualifying premises, and specified use need to be understood. So if you've got a building or space that's outlined within the Act, you need to know. If it's capable of holding more than 200 persons, even on an occasional basis, you need to know. If it's 800 persons, you really do need to know. And is there anybody else that has some form of accountability, responsibility, or control over the premises? And whilst the provisions are going to be implemented over a 24-month period, responsible persons really should be planning and budgeting now. We would strongly recommend that you look to develop a management system to manage security arrangements, to start auditing if you've already got arrangements in place, and reviewing or developing your policies and procedures. Make sure that you start considering security-based risk assessments if you haven't already done so, training or even retraining your staff, and undertaking emergency planning and preparedness exercises, and then reviewing your first aid provisions and facilities. Shaunna, back over to you.
Brilliant. Thank you, David. Very informative, and it has certainly got our attendees asking a number of questions. So just to clarify, yes, we will be able to issue certificates for as part of your CPD, and you will be able to receive a copy of the slides. As mentioned, we will also upload a copy of this webinar to our YouTube channel. So majority of the questions, and I don't think we'll have much time to go through every one, David, but it seems to be the debate as to what is a qualifying premises and what is not a qualifying premises, which is probably what we kind of first thought would happen with this act. So we have one question from Gary. Would a large multi-tenanted office fall under the qualifying premises usage?
No, if it's used solely or mainly as an office. If you have, for example, I mean, we've got lots of clients who have got spaces within their offices, such as theatres, lecture theatres, or spaces where they can hold events. Now, if you are inviting people from outside the business into that event, and that could be 200 persons or could hold 200 persons, then it's potentially that particular area could be a qualifying premises. It's unlikely, though, that an office is, an office certainly isn't a qualifying premises. But we need to think about parts of the premises and what those parts of the premises will be used for. As I say, some of our clients do have lecture theatres or large areas where they can hold pretty large events within their office areas.
Okay, thank you, David. Alex has asked, would a planned or unplanned protest be considered as a qualifying event?
No.
Okay, that's probably the quickest answer you've ever.
That's nice and simple.
Brilliant. Alice has asked, if we have a residential building that has commercial and a retail space within it, to what extent is the residential agent going to need to engage with the commercial space operators?
They're going to have to cooperate and coordinate. The commercial space operators, if they are a specified qualifying premises, will have responsibilities, but those who are responsible for the parts of the building or parts of that premises that are not a qualifying premises or space still have a duty to cooperate and coordinate their activities and to act jointly. So there is a need to ensure that, this is why we were talking about, I mentioned earlier that some unusual buildings that people who say, oh, we don't hold any accountability or hold any responsibility for a qualifying premises. But if your building is part of the building that is qualified, then you do have a duty to cooperate and coordinate.
Brilliant. Okay, I think we've run out of time. I do see questions that are still coming in. So what we will do, we will gather all of these questions and send out an FAQ to everybody. I can see kind of David, Amy, Liam, a number of questions coming in. All seems to be around that determination, David, of what is a qualifying premises and qualifying event, which I think is only going to be at the beginning of us kind of discussing this in the near future. So thank you very much for the webinar today. Thank you very much to everybody attending. And we will be back very soon with an up and coming webinar. So watch this space. Thank you. Bye-bye.